Thanks, Senator Blumenthal, and thank you all. I regret that Osama bin Laden brings us to the airport about an hour earlier than we used to go, and I regret that Edward Snowden brings us together today, but I think we have to acknowledge the obvious. There's a public question now about privacy and whether the government is going too far. It's a question many of us contemplated in the past but could never discuss openly. Now that this is a matter of public record, we have this hearing, as we should, to try to restore the confidence of the American people. Several of you are authors, and I've read your works on a lot of different issues, but the issue before us today is one where the word is not even found in the Constitution: privacy, and what we can come to expect and what the court might view as going too far, any court might view as going too far, and whether the court of public opinion would view as going too far. When you consider the incredible advancement in telephone technology, smart mobile phones, the ubiquitous use of the internet, is it time to revisit whether Smith versus Maryland is in line with the expectations of the American people about privacy? In a world that we live in where phone booths are viewed as some quaint anachronism, and people stand up in the middle of a crowded plane and broadcast their telephone conversations to everybody within earshot, where we know that commercial invasion of our personal privacy is taking place almost constantly, and the accumulation of information by our government is only a fraction of what the commercial sector is gathering about us every single day and every move we make. Take a step back and get to altitude here and tell me what you think the issue of privacy looks like.
Senator, from a 100,000-foot level, we do believe that in the current technological environment, if people use the internet or the telephone or banks, it is right, certainly as a matter of public policy, to protect their privacy and to focus on striking the right balance between national security needs and the needs of government to get access to information that can protect us against those who would do us harm. So we were not asked to investigate the constitutional issue as if we were judges, but we were alert to your concerns very much so in offering our recommendations.
And is it not a fact that if I could obtain anyone's phone logs of the actual phone numbers they called and know the names of the persons they called, I could probably draw some inference about them, their lives, maybe their intentions?
Unquestionably. So metadata is not the same as content, but it is something that people are understandably skeptical of the idea that others get access to, especially the government, for exactly the reason you give.
And if we let the telephone companies retain possession, pardon me, of this data and go after it as needed, what kind of obstacle does that create in going after bad guys, Boston bombers, where we might come up with a telephone number and need to know pretty quickly whether this is isolated or part of an international effort?
If there's a need, either because something bad has happened in the recent past or because there's reasonable grounds to believe it's going to happen in the near or pretty near future, then if time is of the essence, there's no need to go to court. So we would design our recommendation and the legislation that would respond to the recommendation in a way that acknowledges that sometimes you have to move very fast.
Senator Coons raised this question, I'm sure it's been raised earlier before I came, about adding some balance to the FISA court so that there is at least something akin to an adversarial proceeding, or at least both sides of the issue are being heard. What do you feel, based on the work that you've done, is the most credible way to establish that?
Thanks, Senator. I'll just say a couple of things that are in our report. One thing is that trying to think about who those people are institutionally, something that I think deserves some public attention. The people who would be advocates would have to have a clearance because they'd have to be working in the FISA court. You'd want them to have some continuity over time so that the last case is known to them enough so that the next case makes sense. And it might not be a full-time job because it's only occasionally that the big minimization cases happen.
Who would they work for?
Well, and so we suggest some ideas that hadn't been as much discussed in the public before that. One idea would be to put it at the PCLOB, the Privacy Board, or whatever you call it going forward, because they have a lot of other jobs to do and they have lawyers. Another possibility is to put it out for bid so that some law firm or public interest group would have 3 or 5 years where they're doing it. They have a day job, but when it's important to do it, they're there to do it. The concern is if you just sort of pop in and out, you wouldn't have the technological and other context to do it well. And if you sit there full time, you have nothing to do for weeks at a time, possibly.
We have this quaint concept of an inspector general in departments, working at the department but not for the department, literally charged with taking a look from an outside point of view, and most of them emerge with some credibility because of this relationship. Is that something that we could build on?
Historically, my understanding is the IGs haven't had a legal function. That putting a legal office in the IG would be, you're saying my understanding is that they've had fraud, waste, and abuse, but not being the best lawyers you can get. If you want the best lawyers you can get for privacy and civil liberties, arguing with the court and with the very great lawyers in the Department of Justice, thinking about how to staff that so you'll have really good people available, and they probably need something else to do the days of the week when they're not doing this because there's not that many cases.
I might just close by saying two things. First, the pending Appropriations bill, the omnibus bill, contains some provisions which I've added that will finally make public as much as can be made public, a lot of specific data about what has been collected and why it's been collected and what the results of the collections has been. It's been an issue that's been important to me for a long time, and it's going to be part of the bipartisan bill. And finally, I support what Senator Blumenthal is trying to do to make sure these FISA courts are more balanced in the appointees. Not to take anything away from the current process, but I think if there were more diversity in the selection, there'd be more confidence in the outcome. And I think his legislation is a good move. Thank you.
Thank you, Senator Durbin. Just to